Welcome to the Supreme Court of the United Kingdom, where we are hearing an appeal in the case of Highbury Poultry Farm and the Crown Prosecution Service. The court hearing the appeal comprises myself, Lord Lloyd-Jones, Lord Kitchen, Lord Hamblin, and Lord Burrows. We are currently hearing submissions on behalf of the CPS presented by Mr. David Perry QC, and I'll invite Mr. Perry now to continue his submissions.
Thank you very much, my Lord. Lord, may it please the court, may I encapsulate our submissions in relation to recital 3 of the EU regulations at page 577 of the bundle, just to deal with, to finish the point that we were dealing with just before the short adjournment. Our submissions, recital 2, our submissions in relation to recital 2 can be seen from its structure, and it begins by saying that killings may induce pain, distress, fear, or other forms of suffering, even under the best available technical conditions. It refers to the fact that killing may be stressful and stunning techniques may present certain drawbacks. And then it says business operators or any person involved in the killing of animals should take the necessary measures to avoid pain and minimize the distress and suffering of animals during the slaughtering or killing process, taking into account the best practices in the field and the methods permitted under this regulation. And then is the important operative provision. Therefore, pain, distress, or suffering should be considered as avoidable when business operators or any person involved in the killing of animals breach one of the requirements of this regulation or use permitted practices without reflecting the state of the art, thereby inducing by negligence or intention pain, distress, or suffering to the animals. Our submission is the recital is not saying that negligence or intention is required to demonstrate a breach of the regulations. It is saying that a breach of the regulations or the permitted practices which reflect the state of the art requirements would itself amount to some failing committed either because the person or business operator was negligent or that it was intentional. In other words, it is the regulations that are setting the standards. It is not for the standards to be separately assessed by the court in subsequent proceedings. And recital 2 is illustrative of how avoidable pain and suffering is caused, namely by, or is capable of being caused, namely by a breach of the regulations. So that I hope makes our submissions clear in relation to that. The other matters to which we would make reference, I've already drawn the court's attention to recital 3 on competition, recital 4 on animal welfare as a community value. I won't read them out unless I'm asked to. The other relevant provisions are recital 5 makes reference to competition and national laws concerning the protection of animals at the time of slaughter has an impact on competition and on the operation of the internal market, and it's necessary to establish common rules in order to ensure the rational development of the internal market in those products. Similarly, recital 10, conditions under which animals kept for farming purposes are killed have a direct or indirect impact on the market for food, feed, or other products, and on the competitiveness of business operators concerned. And the distinction between the dimension of this regulation, which is directed to competitive behaviour, can be seen by reference to recital 17, which deals with, at page 579 of the bundle, which is addressing the issue of private domestic consumption, which is not performed on a scale likely to affect the competitiveness of commercial slaughterhouses. And your lordships will also see the recital 17 continues. Similarly, the necessary efforts required from public authorities to detect and control such operations would not be proportionate to the potential problems to be solved. So that is incorporating into the scheme, or it's acknowledging within the scheme the difficulties of detection and control and issues of proportionality. The other relevant recitals to which we would make reference are first of all recital 57 at page 583. Recital 57 at page 583, which makes clear that European citizens expect a minimum of welfare rules to be respected during the slaughter of animals. In certain areas, attitudes towards animals also depend on national perception, and there is demand in some member states to maintain or adopt more extensive animal welfare rules than those agreed upon at community level. In the interest of the animals, and provided it does not affect the function of the internal market, it is appropriate to allow member states certain flexibility to maintain, or in certain specific fields, adopt more extensive national rules. But there is then this tail piece. It is important to ensure that such national rules are not used by member states in a way to prejudice the correct functioning of the internal market. So you can go further than the regulations, but what you can't do is impede the operation of the regulations. And similarly, recital 60 makes clear that member states should lay down rules on penalties, not liability, penalties applicable to infringements of the provisions of the regulation, and ensure that they're implemented, that the penalties are effective, proportionate, and dissuasive. 61 is relevant because it meets the appellant's argument in relation to proportionality, because your lordships will recall that the argument that's advanced on behalf of the appellants is that there has to be some proportionality exercise read into the operation of these regulations, and also the domestic regulations for that matter. But in fact, the proportionality assessment has been carried out at community level, as is apparent from recital 61. First of all, it begins with the objective, which is to ensure a harmonized approach with regard to animal welfare standards at the time of killing, which cannot be achieved by member states, and can therefore, by reason of the scale and effects of this regulation, be better achieved at community level. The community's competence then is set out, it's Article 5 of the treaty, and in accordance with the principles of proportionality as set out in Article 5, it is necessary and appropriate for the achievement of that objective to lay down specific rules. So there are the specific rules. The rules are in this particular regulation. And for the killing of animals, for the production of food, wool, skin, fur, or other products, the regulation does not go beyond what is necessary in order to achieve that objective. So that is the principle of proportionality. So in relation to the recitals, we would submit.
Yes, a question at that point. Mr. Perry, going back to recital 57 for a moment.
Yes.
Mr. Hockman's explained to us this morning why he says that he has 2 bites of the cherry. Is it your case that if you're wrong on EU law, that nevertheless there's strict liability imposed in domestic law? Do you say you've got 2 bites of the cherry?
Well, Lord, I say this case is about the EU regulation, and that's it.
Thank you.
That's it.
And
then dealing with the substantive provisions of the regulation, which I hope I can deal with shortly. Mr. Hockman has identified the material provisions, but first of all, at page 583, Article 1 lays down rules. The regulation lays down rules, so it's the rules which have got to be observed. Article 2, the definitions, and it's not necessary to dwell on those, but Article 3, under Chapter 2, appears under the rubric General Requirements. And the general requirements for killing and related operations are distinct. They are Articles 3.1 and 2, as is made apparent by Article 3.3. Article 3.1 is animals shall be spared any avoidable pain, distress, or suffering, and we know that it's to be considered avoidable pain or distress if you don't comply with these regulations. And Article 3.2 is a requirement to take necessary measures to ensure that the matters in A to F are observed. Article 3.3 makes it clear that paragraph 1 goes beyond the obligations which appear in Article 3, paragraph 2. So it's obvious that they are distinct obligations. Our submissions in relation to Article 3.1 is that it mandates the avoidance of a state of affairs. It clearly applies to business operators and persons involved in the killing of animals and related operations, and it is a general requirement. It is silent as to mens rea, but the wording of the provision is inconsistent with any implication of mens rea and wholly consistent with strict liability. The language as so as to ensure compliance, that operations shall be designed, conducted, maintained, and operated so as to ensure compliance with the obligations, is the classic language of strict liability. We do not accept that the verb to spare connotes knowledge on the part of any individual. This construction, the construction for which we contend, makes good sense. If the position were otherwise, enforcement would be unworkable, because it would be in most cases, or many cases, impossible to identify the person involved, particularly as the slaughter process is very often mechanized. So we submit that this is the classic language of strict liability, and read together with the object and purpose of the regulation, strict liability is clearly intended. The Article 6 provision at page 586 also makes clear in Article 6, paragraph 2, which is dealing with standard operating procedures, that business operators shall draw up and implement such standard operating procedures to ensure that killing and related operations are carried out in accordance with Article 3.1. Again, to ensure that killing is carried out in accordance with Article 3.1. And Article 15 at page 588, again using the language of ensure business operators shall ensure that the operational rules for slaughterhouses set out in Annex 3 are complied with. Again, that's the language of strict liability, shall ensure that these rules are complied with. And Article 15, read together with Annex 3, which is at page 604, imposes duties on business operators. The duties we submit are strict, and included amongst them is the duty to ensure that carotid arteries are severed on each occasion that an animal or a bird is killed. And we submit that again makes clear that the duty is strict. So far as Article 23 is concerned, again, it's significant that the member states are required to lay down rules on penalties applicable to infringements of the regulation. And they shall take measures to ensure that they're effective, proportionate and dissuasive. And there is no scope for reading into the regulation that the member states are at liberty to lay down rules on liability
Mr. Perry,
for an infringement
Lord,
of
Mr.
the
Perry.
regulation and what an infringement would entail in
Mr. Perry.
terms of mens rea, which would have the effect of disrupting any attempt at harmonisation by incorporating into these provisions concepts peculiarly of English law.
Mr. Perry, are you able to hear me?
No, he's frozen, I think.
Our engineer is getting in touch with Mr. Perry to try to sort out the problem. Before we lost you, Lord Kitchen, I think, was wanting to ask you a question.
Right, thank you very much, Lord. Thank you.
Mr. Perry, might take you back, please, to Article 15 and its relationship to Article 3.
Yes.
You've explained to us that it's your submission that Article 15 creates an absolute requirement that both carotid arteries are cut.
Yes.
The divisional court reasoned that where that does not take place, there is an irrebuttable presumption that avoidable pain is caused within the meaning of Article 3.
Yes.
Now, you haven't mentioned that. Is that part of your case? Do you support that proposition? And if so, could you please explain to us briefly why and how?
Yes. Lord, first of all, the first point is that the structure of the regulations is that they are setting out the standards that the business operator must observe and the standards that must be observed, and these are the necessary measures that must be in place, and they're the state-of-the-art standards, are those which are to be found in Annex 3 to Article 15, or which are incorporated into Article 15, and that includes the severing of the carotid arteries and the verification of the absence of signs of life. And the way that the regulations are structured is, if you don't conform to the operational rules which are which set out the best practices, that is not sparing the animals avoidable pain, distress, or suffering, because that is what, in effect, recital 2 is telling us, that the pain, distress, suffering should be considered as avoidable when you breach one of the requirements. So that's how it works. So we do agree with that, with that construction, my lord.
I understand that you say that the two interrelate, but the divisional court went a little bit further and expressed the conclusion that avoidable pain is actually caused to the animal. Is that a submission that you make?
Well, my lord, I'm not sure if I have to go so far as to that. I probably wouldn't have expressed it quite in the same way that Lord Justice Hickenbottom expressed it in the irrebuttable presumption point. But what I would say, Lord, is that once you've got the breach of the regulation, you've got the avoidable pain, suffering, or distress. You've breached the requirement. That's why you have to have the standard, and why the regulations themselves are setting the standard. That's why it's not for the municipal courts of the member states then to investigate the circumstances as to how the breach actually came about. It's sufficient for there to be the breach.
I think Lord Burrows also has a question.
Could I ask, following on from that, the relationship between the two regulations that are here charged in this sense? From the way that you've so far described it, it would appear that you would automatically have, once you've got a breach of Article 15(1), Annex 3.2, you would also have, on your interpretation, a breach of Article 3, subsection 1, subparagraph 1. Might it be said that that seems duplicitous, that you've got two charges automatically all the time happening? Why wouldn't it be sufficient, for example, in your position, just to have charged under Article 15(1)? Why do you need to add on Article 3(1)?
Well, my lord, that's, I suppose, in essence, that's a question of prosecutorial practice. The first point that I would say is it's not uncommon in criminal cases for prosecutors to put twin charges on a charge sheet or on an indictment. That doesn't mean to say that the charges themselves are duplicitous in the sense that they're charging two offences in one charge. But it may be, for example, that when it comes to the trial, that depending upon the way the evidence developed, either the prosecution might decide to go in relation to one charge rather than another, or if there were to be convictions recorded in relation to both charges, then there might not be any separate penalty. But, my lord, what I would say in relation to that is that that's a matter of practice rather than the interpretation of the regulations themselves. And one of, I'm sorry, my lord, I'm sorry.
Could I then just follow that up? Is it possible that some of these offences are offences of strict liability and others are offences not of strict liability? I mean, it looks as if some of them are concerned, for example, with due diligence and so on. But might it be said that while Article 15.1 is an offence of strict liability, Article 3.1 might import negligence or intention because of the recital 2?
Well, my lord, no, because if you start to split out which offences are ones of strict liability and which are not, the scheme loses its coherence. And immediately you then have to investigate the precise and particular circumstances in each particular instance in which there's been a breach of the regulation. And for the reasons we've advanced, recital 2 is making it clear that it is the breach of the regulation which provides the basis of fault. So, Lord, we would submit that that would not be a permissible reading of the regulation. I hope that's clear. That's the way we put it.
Can I? I'm sorry, Mr. Perry, to have put another question to you.
No.
I understand the argument that where there's been a breach of Article 15, any resultant pain suffered by the animal should be treated as a matter of law as having been avoidable.
Yes.
But I wonder if it isn't going too far to say that one can infer irrebuttably from Article 15 that the animal has in fact suffered pain. The present case is perhaps an example where the animal has been stunned before being scalded, but hasn't had its throat cut. And one might have thought there might be a need for veterinary evidence as to whether under those circumstances the animal is likely to have suffered pain or not.
Well, my lord, I would submit that there wouldn't be a need for evidence or to investigate that sort of issue, because the proper basis of liability is the fact that you haven't conformed to the regulation. You're in breach of it. What you can't have under these regulations are veterinary experts lined up by the prosecution and the defence, with the magistrates' court having to reach a conclusion that the prosecution experts who said the animals did suffer pain are to be preferred to the defence experts who said they did not suffer pain in these circumstances. If anything is going to distort competition in the internal market, it is having that sort of debate in a tribunal which is supposed to be adjudicating on matters as expeditiously as possible.
Well, I see the pragmatic argument, but the problem only arises because of the practice of charging a breach of Article 3 along with a breach of whatever more precise article it is that's also being breached.
Yes, yes. Well, my lord, what I would say in relation to that position, suppose we were dealing with a case here where only the Article 3 point, the only breach was the Article 3 breach, you would be in the same position. You would be in the same position because you would be relying on exactly the same factual foundation for your case as you would be in relation to the Article 15 breach. And you would be saying, in relation to the Article 3 breach, that the breach of the regulations is itself what provides the basis for the unnecessary pain, suffering or distress.
Lord Kitchen has a question.
Oh.
Mr. Perry, I'm sorry just to pursue this one, but it has troubled me. And I may I put to you that your submission to us is not consistent with Article 3, paragraph 2, subparagraph D, because that imposes upon the business operator an obligation to take the necessary measures to ensure that the animals do not show signs of avoidable pain. And that would be is that not an indication that it doesn't necessarily require complex evidence, but you're not going to get home under Article 3.1 unless there is some indication from the state of the animal itself that it is in pain or was in pain for a short time before it was scalded?
My Lord, no. For this reason, my Lord, that the obligation in 3.2 is distinct from 3.1. 3.2 is making it clear, and that's why 3.3 is so important, because it's making it clear that they're distinct obligations. It's hardly.
The opening words of 2 provide the link.
Yeah.
But Lord, what it's not surprising that there is an obligation to take necessary measures to ensure that animals do not show signs of avoidable pain or fear or exhibit abnormal behavior. But that is not the same as saying if you have a breach of Article 15, Annex 3, the requirements there, that you then have to go on to show for a breach of 3.1 that there were signs of avoidable pain or fear or abnormal behaviour. So, my Lord, that would be the way that I would construe it, and invite the court to construe it. Lord, we've dealt with we've dealt with the regulations and the EU regulations. May I turn to if it's convenient to the court, turn to the domestic regulations, which are at page 749 of the bundle. And the point about the domestic regulations is that they are simply the mechanism by which the EU regulation is enforced, and the relevant provisions in relation to penalties are found at 759, and your lordships have been referred to the particular provisions. It is also relevant to look at Article 31, which has got the obstruction offences, which are classic domestic offences, which are in support of the EU regulation, but don't involve breaches of the regulation, but it's all to do with obstruction offences, to do with enforcement. And also Regulation 32, which is offences by body corporate, is the classic type of domestic law provision which would not be consistent with a Tesco and Natras type corporate liability through rules of attribution, because it's making it clear that where a body corporate is guilty of an offence, then other individuals may be guilty where the offence has been committed with their consent or connivance or attributable to their neglect, and then the penalties are, in the case of a corporation, simply without belittling it at all or trivializing it, but it's to a financial penalty. Lords, what we submit is that there is nothing in this domestic instrument to suggest that contravening the EU regulation involves mens rea, and the contrary is in fact the case. The EU regulation is the governing provision. The domestic regulations must be interpreted in conformity with the EU regulation, and the domestic provisions cannot alter, modify, or add to the scope of the EU regulation. But, my Lords, may I just say something? It doesn't arise for determination, but it is a point that has been raised by my learned friend in relation to the various means by which the offence, contrary to Article 30, paragraph 1, could be committed. At page 759, the court will recall it is an offence to contravene and then or to cause or permit a person to contravene. The submission that was made to the divisional court and the submission that has been made to your lordships is that to cause or to permit would ordinarily connote some form of mens rea. The way the divisional court dealt with that was to rely on the case law, which makes it clear that it is possible for the verbs to cause and to permit to connote mens rea, but also to be used in offences creating strict liability. And the decision, the most familiar decision in this field is James and Son Limited and Smee, which is at page 1095 of the court's bundle. I won't turn it up unless your lordships want me to, but the statements of principle can be found at in the judgment of Mr. Justice Parker at 1108, 1109, and 110. Mr. Justice Slade took a different view in his dissent and held that the offence creating provision was a wholly strict liability offence. The point of referring to this is that it is not, although it doesn't fall for determination, there are authorities to suggest that, as one might expect in this context, it all depends on how to construe the words in their statutory setting. And for a discussion on this point, Mr. Justice Dixon in the Supreme Court of Canada, in the Sault Ste. Marie case, which is at page 1259 of the court's bundle, addresses what he calls these troublesome words at page 1287 to 1288. And he says the arguments can go either way, depending upon their context. And certainly it is the case that the authorities before included in the court's bundles show that the context, together with other sufficient indications of a different intention, are sufficient to displace any presumption of mens rea in relation to causing or permitting. And a good example is Gammon, the Hong Kong case before the Privy Council, which is in the court's bundle at page 984. See the discussion of Lord Scarman. at page 1001 to 1002. So, but in any event, we submit that the divisional court was correct to conclude that the offence of contravening is an offence of strict liability. Our submissions on the domestic regulation are that, having regard to the nature of the crime, the level of the penalty, the absence of what we would call social stigma, the field of activity, the wording and context, and the clear intention of the wording was to impose strict liability. May I then turn to address the argument that strict liability in this context would have no effect on operating standards, because a person cannot be dissuaded from doing something if that person cannot prevent the prohibited result from occurring. We do not agree with the appellant's submissions for three principal reasons. First, there has been no finding that the appellant company has in fact done everything which it could reasonably do to secure compliance with the EU requirements, and ipso facto, as a result of the breach of Article 15, we would submit it as not. Second, in any event, the business operator can be expected to influence or control the process of killing. So this is not an instance of the useless and unjust infliction of a penalty, to use the words of Mr. Justice Devlin in Ronalds and Austin, which can be found in the bundles at pages 1358, and Mr. Justice Devlin's observations at 1372. And third, the business operator can be induced to keep themselves and their organizations up to the mark, and strict liability is likely to promote greater vigilance and higher standards. It is possible that by supervision, inspection, and improvement of business methods, that the observance of the obligations set out in the EU regulations will in fact be promoted. And in sum, we submit that strict liability promotes the high standards of care, and the threat of criminal liability supplies the motive for business operators to conform with the requirements within the regulation. I've made it clear that we say that the EU regulations are the beginning and end of the argument. Your lordships know that so far as the presumption of mens rea point is concerned, we submit it has no application in the context of this case, for the simple reason that the powerful domestic common law presumption of mens rea is deprived of any potency by the context in which these issues fall to be decided, namely an EU regulation concerned with animal welfare and avoiding distortion of the internal market. Having said that, your lordships know from our written submissions that even without the European law context, we submit that the domestic regulations do not create offences involving mens rea, and in summary, they're not truly criminal offences. The authorities recognise the presumption of mens rea can be displaced by express words or necessary implication, and here the necessary implication is clear. Third, the implication is compellingly clear because it's only through strict liability that the objects of the legislation can be achieved. and the appellant's arguments would render the scheme both unworkable and impracticable. The statements of principle in the case law are adequately summarised, conveniently summarised by Lord Scarman in Gammon at page 995 to 997 of the bundle. And we made our submissions in relation to negligence. My learned friend didn't rely or didn't develop his submissions in relation to the decision of the Court of Appeal in the Queen and Riley, which it had been submitted in his written case, had answered N's rare question, or at least was supportive of his case. That's at 1377. Our simple submission in relation to Riley is that it was not dependent for its effect on an EU regulation, clear and specific, underlying underlying the court's reasoning. We also take issue with the suggestion that there has to be some form of attribution of liability to the company through a sufficiently senior representative of the appellant corporate entity. In our submission, the analysis of liability in this case is, it is first of all a strict liability. It can be incurred by one or other of two means. It can be incurred directly through the business operator, or indirectly through the operative or employee. But whichever it is makes no difference to the ultimate result, because whether it's directly or indirectly, in each case it is the business operator's act or omission. And that is consistent with conventional principles of criminal liability as made clear in cases dating back to the 19th century, such as Coppen and Moore, page 930 of the court's bundles. See page 937 for the observations by Lord Russell, Chief Justice, and at page 938, that was a sale of goods where Mr. Coppin was the seller through his employee. There's also Perks, Gunston and T, page 1179 of your Lordship's bundle. See the discussion at page 1189. And for a more recent application of the principles, Harrow, London Borough Council and Shah, page 1004. See Mr. Justice Mitchell at page 1011 for the principles of vicarious liability. And while we accept that it's correct as a general principle that criminal liability ordinarily results from personal fault, in this case the liability attaches to the business operator because the prohibited act has taken place during the course of its operations, and those operations are subject to its supervision and control. And it is not unusual in this type of context to have strict liability. So, my lords, may I then make our concluding remarks, which I can express quite briefly. First, the EU regulations are not only designed to promote the welfare of animals in slaughterhouses, they are intended to ensure fairness between business operators and ensure the efficient and proper working of the internal market. To incorporate, for example, rules of attribution would create real difficulties in this context. It is a notorious fact that the directing mind and will basis of liability has caused great difficulties in locating fault in cases of corporate wrongdoing. See, for example, the discussions in Tesco 1438, Seaboard 1390, and Meridian, Lord Hoffman 1148. The point being that there has been no satisfactory basis for determining corporate liability across a range of offences, and it still has scope and potential to create difficulties as a matter of English law. It is notoriously difficult to bring home liability. When the scope and objective of the regulations are borne in mind, we submit it's obvious that liability is strict. The business operator is in the best possible position to ensure compliance with the requirements, and strict liability ensures that business operators are not able to hide behind the actions of individual operatives, and there is nothing oppressive or unreasonable in the imposition of strict liability in this specialised area. And for those reasons, and for the reasons set out in our written submissions, we submit that the Divisional Court was right to conclude that proof of neither knowledge nor culpability is required, and we would invite the Court to dismiss the appeal for the reasons set out in our submissions. My Lord, if there's any matter upon which we can assist your lordships in relation to any of the materials, we will of course endeavour to do so. But my Lord, those would be our submissions on behalf of the respondent.
Could I raise one matter with you, Mr. Perry? We're under a duty to refer questions to the European Court of Justice if it's necessary for us to to answer the question, and the answer isn't already clear. There's evidently been some, you've encountered some pushback from some justices on a number of points, most of which I think relate to Article 3.
Yes.
Yeah, and on the issue about whether a breach of Article 3 follows automatically from a breach of Article 15, that particular question isn't the focus of the appeal, but
no.
It is a matter on which there is a decision by the Divisional Court.
Well, your Lordship will not be surprised to know that our submission is that the position here is clair. It is absolutely clear, and the recitals make. We would submit the recitals put the point beyond argument, as do the requirements of Article 23 and the way that this has been incorporated into municipal law by the domestic regulation. And, my Lord, what I would submit is that the key to this case is the distortion that these requirements would bring into the regulations, when in fact Recital 2 is making it clear that once you've got the breach, that's it. And that's the only way they can operate. It's the only way they can operate as a matter of liability, and it's the only way they can operate having regard to issues of competitiveness. So we would submit, my Lord, that that's the position.
Thank you. Well, if there are no more questions, then I'll invite Mr. Hockman to reply.
Thank you very much, my lord. Thank you.
Thank you.
Thank you, my lord. Can I just check that everyone can hear me, please? I'll assume that they can, unless I'm told otherwise.
Yes.
In my reply, I'd like to cover three main areas. I'll try and avoid repeating the submissions that I made in my opening. Of course, we continue to rely on all of those, as well as everything we've said in our appellant's written case. But the first area that I'd like to cover is to emphasize that we do still submit that on a proper interpretation of the EU regulations, there can be no contravention on the part of the business operator without some element of fault on the part of the business operator. We have throughout put that as our primary submission, and we do rely on all the arguments that we advanced in opening. But let me make a few points in response to what has been said against us on that first issue. And let me invite your lordships, please, to return, not for the first, but perhaps at least in the hearing for the last time, to recital 2 on page E577, if we could go back to that. And in particular, the final sentence of recital 2. And one can see that there are really two broad aspects of that, two broad elements in recital 2. One is the question of pain, distress, or suffering. So recital 2 is showing that it is an objective of the regulation, a very important objective, to bear down on pain, distress, or suffering. And that clearly raises the question, in any case where there is said to be a contravention, whether pain, distress, or suffering has taken place. Now, I would interpolate there this comment, if I may. I don't want to major on this point, but I would say with respect that my Lord Reed was absolutely right in putting to Mr. Perry that it does not follow from there being a breach of Article 15 that there was necessarily any pain, distress, or suffering at all, avoidable or otherwise, and that therefore it does not follow as a matter of law or by some irrebuttable presumption that a breach of Article 15 automatically leads to a breach of Article 3. I was gratified to hear my Lord make that point, because it was a point that I myself had made in criticising and challenging the decision in this respect of the Divisional Court. But the main point that I'm making, reverting to recital 3, is that the first element in recital, reverting to recital 2, I'm so sorry, is that the first element is pain, distress, or suffering. But then the second half of the sentence identifies what the draftsman of this legislation considered to be the circumstances in which pain should be considered as avoidable. It really provides a definition of avoidable pain. It shows what sort of pain is considered avoidable and against which the regulations are aiming. And what it's saying is that pain should be considered avoidable when either the business operator or any person involved in the thing, presumably primarily an operative, breaches one of the requirements. Let's leave aside the other requirements. Breaches one of the requirements, thereby inducing by negligence or intention, pain, distress, or suffering. Now, we submit that within that second part of the final sentence, there are these components. It's dealing with the question of whether the pain is avoidable. It's dealing with the question of breach, either by a business operator or an operative. And it's saying that any such breach is induced by negligence or intention. And that must mean negligence or intention on the part of the person responsible for the breach. There is no other sensible, linguistic, rational way to interpret the language. So you simply have to focus, when an allegation of this sort is made, on whether there has been avoidable pain, whether it has been brought about by a breach by the business operator or by an operative, and whether it has been induced by negligence or intention. No sophistry, if I may respectfully say so, in the interpretation of language can escape the need to focus on those elements in what I've called the second part of this sentence. And in particular, when an allegation is made, as it is by the prosecution here, that the business operator has breached the regulations, one is entitled and indeed absolutely required to ask, have the prosecution shown that the breach gives rise to avoidable pain, and have the prosecution shown that this is the result of negligence or intention. Not to proceed on that basis would be to set aside this crucial provision as to the objective. And with great respect, it simply cannot be an answer. Simply cannot be an answer to those comments to say, oh, well, we have to achieve consistency. Yes, of course, consistency was another objective. But the question is, on what basis is consistency going to be achieved? It could be consistency in the penalisation of people who are not in any way to blame, if that were thought to be a laudable objective. Or it could be, as we say, is much, much more likely, consistency in the penalisation of those who are at fault. But to say that you need to achieve consistency tells you nothing, doesn't in any way point to the one or the other. If anything, it points towards a requirement of fault, because that is a much more worthwhile objective if consistency is your aim. So we would say, taking these basic ideas as our starting point, that they are supportive of the case that we have sought to put forward. And that is the essential argument under the first heading of my reply. Let me add one or 2 points more, if I may. First of all, I wouldn't accept, I know this point arose and I'll be coming back to it under my second heading, but I wouldn't accept as part of my primary argument that if the case is being brought against the business operator, that it's sufficient to establish fault on the part of the operative. That is not, we would say, a legitimate reading of the objective of the regulation based on recital 2. Secondly, Mr. Perry laid a lot of emphasis on the difficulties that might be faced in bringing proceedings. I don't think anybody has ever suggested this hitherto in relation to this regulation. He was particularly concerned about the difficulties that might be faced in taking proceedings against corporate business operators. But surely that point can be made when any criminal proceedings are brought against a corporate business operator, whether in any other member state or in the United Kingdom. Of course, it raises its own issues but those issues are not insoluble. And if those were thought to be issues, then it would have been open to those drafting the regulation expressly to seek to bypass those issues, expressly to impose an absolute duty on corporate business operators as opposed to individual business operators. The regulation does not distinguish between corporate business operators. And in our submission, one can assume, indeed it's the only reasonable assumption, that in the process of enacting this regulation, in the process of achieving, if you like, democratic consent for this instrument at a European level, that it was felt necessary to ensure that a requirement of fault was included, and that it was not appropriate or feasible on the part of the regulatory authorities to achieve an outcome in which people could be penalised for having done nothing wrong. That would be the right thing to do. So that's the primary submission, and it's the submission that we've made throughout in this case and to which we appeal. Now, my second submission is really to revert to the issue which was touched upon mainly in the first half of Mr. Perry's response before the midday adjournment, which is whether, if we're wrong on submission number 1, then we still have the ability to advance argument under domestic law to have what has perhaps less than seriously being described as a second bite of the cherry. I think it was a phrase that originated in the words of Mr. Justice Jay, and I don't mean in any way to be critical. It's a useful way of encapsulating the point. Now, on this part of the argument, and only on this part of the argument, without conceding anything in relation to my first submission, I would observe that at the very minimum, if I can put it in this way, at the very minimum, if the prosecution are going to be able to allege a breach on the part of the business operator, then at the very minimum what they have to do is to allege fault on the part of an operative. If nobody at all is at fault, then surely it cannot possibly be determined that a breach in accordance with the objectives set out in recital 2 can have occurred. So the very minimum that the prosecution would have to do is to identify fault on the part of an individual operative. And that, in our submission, provides us with the gateway and illustrates the applicability of the gateway provided by the Van der Ven case. And I'd like to go back to Van der Ven, which is at page 970, that's the Advocate General's opinion, and 976, the judgment of the court. So if you kind enough to open it up, firstly at page E970, the opinion of Mr. Advocate General Van Gerben. And this has been authoritative since the early 1990s. We can see. Now, I think we touched on this in opening, but if we didn't, let me touch on it now. We can see firstly, and this is in effect the equivalent to Article 23 in our regulation, that at paragraph 2 of the Advocate General's opinion, you have a reference to Article 17.1 of the regulation concerned in that. Required member states to adopt the provisions necessary for the implementation of the regulation. Such measures must cover inter alia the penalties to be imposed in case of breach. So you have a very, not in exact words, but an analogous provision. Provisions necessary for implementation, such measures to cover inter alia the penalties to be imposed in case of breach. Very similar to the reference to infringement in Article 23. But also similar in giving a considerable latitude, a considerable margin of appreciation to member states. And that was what the Advocate General said in paragraph 8 of his opinion. If we could go to that on page 973. 973. And he said that he accepted, in accordance with an earlier case, that member states, at the bottom of the left-hand column, member states have a discretion, which it is true, coming into the right-hand column, is subject to two conditions. First, they must ensure that the penalties are effective, proportionate, and persuasive. Secondly, the member states must penalise infringements of provisions of community law in the same manner as infringements of national law of a similar nature and importance. And if there's anything that demonstrates, contrary to the respondent's argument, that I'm entitled to a second bite of cherry, here it is. This is telling everyone that the provisions of national law of a similar nature and importance are precisely the guide to the way in which member states must penalise the provisions of community law. And then the Advocate General goes on, community law leaves the member state free to choose the means for achieving these aims. They may choose between criminal, administrative, or purely civil penalties. They may decide to impose these penalties always on the undertaking, or in certain cases on the representatives or members of staff of the undertaking, with regard who with regard to the specific infringement, bear the actual responsibility for the operations of the undertaking concerned. As long as national rules on penalties comply with the conditions mentioned, then nothing requires the member states to make the legal persons criminally liable. And then over the page at 974, in the right-hand column, saying very much the same thing. But about halfway down the right-hand column, there is this sentence. In a number of other member states, a criminal, administrative, or even civil penalty may be imposed, only on condition that there is some indication at least of negligence, or that the infringement may be attributed to the person to be penalised, or both. And then if one looks at the judgment of the court at E976, and if one goes to, first of all, to paragraph 12 on E980, at the bottom of E980, nothing to require a member state to introduce into its national law a specific system of criminal liability, such as the criminal liability of legal persons, in order to ensure compliance with the obligations imposed by the regulations in this particular case. And then at the top of page 981, as part of paragraph 12, I'm sorry, in fact it's paragraph 13. I'd obscured it with my pen. Paragraph 13, the answer to the second question should therefore be that nothing requires a member state to introduce into its national law the principle of criminal liability of legal persons. Infringements may be restrained by the application of provisions in conformity with the basic provisions of national criminal law, providing that the resulting penalties are effective, proportionate, and persuasive. And then over the page, at page 982, the introduction of that, paragraph 17, I think it is, the introduction of such strict criminal liability on the part of the employer is not compulsory. Article 17 allows member states at discretion as to the choice of penalties to be imposed in the event of breach, which is subject only to the obligation resulting from Article 5. It is therefore not possible for a member. It is therefore possible, I should say, it's therefore possible for a member state to comply with those obligations, whilst choosing not to provide a strict criminal liability on the part of the undertaker. And if that is the law, that is component of EU law, and if the situation is that an event has occurred which was within the control of the operative, the employee, and for which the employee was at fault, and if despite that the prosecution choose to proceed against the blameless employer, then they cannot complain if the court decides that it was inappropriate to proceed against the employer, because under domestic law, strict liability, in the sense of liability without fault, does not arise and is not imposed. So in short, Van der Ven clearly allows me to have a second bite of the cherry, clearly allows me to say that even if under EU law, even if under the EU regulation, under Regulation 1099, fault does not need to be proved, it's open to me to submit that fault nevertheless needs to be proved under domestic law. That brings us finally to the domestic law position. Mr. Perry, in the course of his submissions, was, I think, if I may say so, a trifle schizophrenic, because in answer initially to my Lord Lloyd Jones, he rather gave us the impression that he wasn't making any submissions about domestic law, and that in his submission the case turned entirely on EU law. Nevertheless, he went on to make some submissions about domestic law. But our respectful response would be that they were unpersuasive. We still rely on the notion of mens rea, which is so important as an element in our domestic criminal law. But perhaps more importantly for present purposes, we also rely on the way in which, in this type of case, the notion of strict liability has been defined and articulated by judges of the utmost repute and at the highest level. One thinks of Lord Steyne in Bede, making clear that that's because it's a matter of social concern, that doesn't tell you whether liability without fault is necessary or has been determined to be applicable. But perhaps more importantly than that, you have Lim, which I refer, the opinion of Lord Evershed on behalf of the Privy Council, making it clear that even strict liability depends upon there being an element of criticism, depends on it being a case in which the employer could have done more. That was the phrase, I think, in the Matudi, the Court of Appeal case that I mentioned. We haven't looked at that in great detail, but Lord Justice Scott Baker in his judgment in Matudi clearly says the appellant could have done more. In Lim, it's clearly stated by Lord Evershed that it is inappropriate to penalise people who are beyond criticism, and some of the policy reasons behind that are very clearly articulated by Justice Dixon in the Canadian case, which I drew to your attention. And then you have Lord Diplock, no less, in Tesco and the Trash, the passage to which I referred you, in which again he says there is no point in penalising someone who has done all that he reasonably can. That word reasonably is there in Lord Diplock's speech in Tesco and the Trash, to which I drew your attention. And although I listened very carefully to Mr. Perry's, if you like, policy response to this towards the end of his submission this afternoon, when he said, well, we do say that penalising people who aren't to blame will induce greater vigilance, I would submit with great respect that that was assertion and not argument. It has sometimes been treated as obvious that if you impose strict liability, meaning strict liability without any want of care whatsoever, that would encourage greater vigilance. But we would submit that when you actually look at the authorities which support the notion of strict liability in cases of social concern, they don't support that interpretation. Certainly not those at House of Lords and Privy Council level, and certainly not on the basis of the rationale so clearly articulated by Justice Dixon. There are some cases in the lower courts, one or two of them Mr. Perry mentioned, without taking through them, particularly I think cases where the employer is held liable because it's the employer that made the sale. That's the most typical example. Certainly when I attended lectures in criminal law given by Professor John Smith, those were the cases that were imprinted on one's memory. But those are cases on other legislation, and they're not cases in our respective solution in which a general principle is laid down. So in a nutshell, we are inviting the court to analyse this case both from the perspective of EU law and from the perspective of domestic law. We do acknowledge, of course, that the court may in certain circumstances have a duty to refer this case to the Court of Justice, but like the prosecution, but for rather different reasons, we submit that on EU law the matter is at clear. So it's certainly not something that we submit is necessary, or that we, as it were, would be encouraging the court to do, although we acknowledge that that is a matter that the court may feel that it has to consider. But irrespective of EU law, if we're right in our analysis of Van der Ven, and if we're right in our espousal of the well-known, increasingly well-known principle of the second bite of the cherry, then the domestic law position we submit is clear, and the prosecution has not provided a convincing reason why some degree of want of care should not be required. So that leaves only the question, although it's a very, very important question from the perspective of my client's Highbury Poultry, what should the outcome be? But for one point, it might be thought that the outcome should be that this court should, as it were, reach its conclusions on the law, declare what the law is, which is, of course, if I may say so, respect this court's responsibility, and leave matters there and leave it for the criminal trial process to take its course. But in our submission, this court is relieved of the need, as it were, to add that particular coda to its decision because of the concession in this case. It's contained in the statement of facts and that there is no systemic blame attached to the business operator. We expressly raised that point and the concession has been made. And so we would not accept that there is any other appropriate outcome in this case, but an acquittal if your lordships rule in our favour, either on EU law or on domestic law or both. And we would invite the court so to decide. Obviously, the precise form of order would be something that can be agreed, I'm sure, between the parties upon receipt of the ruling of the court. I hope it's not presumptuous of me in those brief terms to address the way in which, on behalf of the appellant, we see the position in terms of outcome, although of course our primary concern is to persuade the court on the legal issues which will be the subject of controversy this morning and this afternoon. Unless I can assist further, those are our submissions in the trial.
It doesn't look as though we have any further questions for you, Mr. Hockman. Thank you very much. Well, we're grateful to both you and Mr. Perry for all the assistance that you've given us, and also to those who no doubt have been working behind the scenes. We'll take that time now to consider the submissions, and we'll let you have our decision as soon as we can. The court will adjourn.
Thank you.